Hi, this is Kyle Sofkowski, and in this video we're going to be looking at the First Amendment with respect to religion in Unit 3. And with respect to religion, the freedom of religion, perhaps one of the most important aspects in the First Amendment is something called the Establishment Clause. And in the First Amendment, you'll read, "The Congress shall make no law respecting the establishment of religion." That right there is, of course, known as the Establishment Clause. And what this was meant to do was to prevent a national religion. Going back to more historic times in the 1600s, 1700s, and even earlier, it was very common, especially in European countries, to be affiliated with a particular religion. Now, certainly it makes sense in this case. However, does this mean that government cannot favor one religion over another? Does this also mean, as per Thomas Jefferson, that there should be an entire separation of church and state that forbids favoritism and support for just all religion in its entirety? And this notion of the wall of separation establishes what you might have heard, colloquially speaking, known as church and state. That's a very commonly used phrase. However, it actually does not go anywhere. You cannot find it anywhere in the U.S. Constitution as it is connected here. And what Jefferson is saying is that there should be a separation of church and state, meaning that there should be a separation between the government and religion in and of itself. And certainly this is the bedrock of the Establishment Clause. But you'll see here that the Establishment Clause is very, very ambiguous. It is not spelled out all that much. But a few cases I want to review with you, and some of them are going to be required, some of them are not. But this, again, works into the background of the First Amendment with respect to religion. First thing I want to go into is Lemon v. Kurtzman in 1971. And what this was about was you had taxpayer money going to church-related schools. For example, money was being used for students to be transported with school buses and textbooks and whatnot. Of course, this evolves into a Supreme Court case under the Establishment Clause. People were saying, hey, my taxpayer money is going to be used for church-related schools. Isn't this a violation of the Establishment Clause? Well, the Supreme Court came back and said, really, no, not so much. What they're going to do is establish what's known as the Lemon test, and oftentimes courts are going to be creating these tests for the lower court to understand and how to rule in similar types of cases. And what it says is, well, it's constitutional if it meets this three-pronged test. Does it have secular purpose? And in this case, yes, it's to educate kids. Does it have a primary effect that neither advances nor inhibits religion? Since this would pertain to all types of religious schools, certainly would meet that second prong. And then the third prong being, does it not foster an excessive government entanglement with religion? And of course, that's going to be somewhat ambiguous as to what constitutes an excessive government entanglement with religion. And again, that's going to be dependent upon the justice's background as well as their political and judicial views. Another case involving the Establishment Clause is known as Engel v. Vitale, and this is a required Supreme Court case to know for the AP exam, and there is a separate video on this case on my YouTube channel should you want to go in more in depth. But in New York State, they actually had a recitation of prayers, and this was non-denominational. It mentioned Almighty God, did not favor a particular religion, but was school-sponsored. It would play over the PA system after the Pledge of Allegiance. And ultimately, this goes to the Supreme Court in 1962, and this, of course, is going to be declared unconstitutional according to the Establishment Clause because it is state-sponsored, it's school-sponsored. So even though the students did not actually have to voluntarily, or actually did not have to participate in this in a mandatory sense, this fact that you were being forced to come to school and being subjected to this was seen as a violation. And again, it is important to note that it is constitutional for students to pray silently as they wish, and they can certainly make accommodations for students who want to do this, but this has to be student-initiated, not by a teacher, not by a coach, and there are many, many, many cases involving this. And again, it's very important to note that the Supreme Court has ruled that the sponsorship or even the encouragement of prayer, directly or indirectly, by public schools authorities to be unconstitutional. But nevertheless, this has been the subject of much controversy, with fundamentalist religious groups even calling for a constitutional amendment for prayer in school. And it is important to note that a majority of the public still supports school prayer. And ultimately, some schools are still defying this particular Supreme Court ruling, because remember that the Supreme Court does not have the power of the sword. It lacks that implementation, so that can be very difficult. But here is a current case as of 2019. This is a case before the Supreme Court, and this was a cross erected in 1925 to honor World War I veterans, and it is on Maryland state property. The problem being that this is being seen by humanist organizations as a violation of the Establishment Clause. So as of the making of this video, the result has not come about. However, I encourage you to look it up should you be watching this after the Supreme Court rules on this particular case in 2019. Now, the other major clause to be aware about is the Free Exercise Clause. So this first part, as we talked about, the Congress shall make no law respecting an establishment of religion, is the Establishment Clause. But the second part of this, or prohibiting the free exercise thereof, is known as the Free Exercise Clause. And basically what this does in a nutshell is it's supposed to prohibit government from interfering with the practice of religion. Generally speaking, this is going to be upheld unless it's an unusual religious act that is illegal, and I'll get into that momentarily. But ultimately, the Supreme Court is constantly trying to balance one's free right to exercise your religion, especially ones of the majorities, with the right to free exercise of minority religious groups as well. And again, here's another case that is not required, but I mention it as some added background to the Free Exercise Clause because it's not absolute. Just because you have the right to freedom of religion doesn't mean you can practice anything you particularly want. For example, some religious practices are going to conflict with rights, and as a result, the Supreme Court can deny those and still will allow the state to punish you if you commit those acts, especially if they are illegal. But one case involving Employment Division v. Smith ultimately comes out with this idea that the court ruled that state laws that interfere with religious practices but are not specifically aimed at religion are constitutional. So, for example, the state of Oregon is allowed to prosecute Native Americans who use peyote, which is a hallucinogen, and is outlawed by Oregon state laws, it is in many other states, as part of their ritual. So just because you say it's part of your religion does not necessarily make it okay to practice if it's outlawed. A more extreme example is, let's say you have a religion that says I'm going to sacrifice a kid, every fifth kid that's born. Well, murder is illegal, and the fact that that is outlawed and you do not allow that under the Free Exercise Clause makes sense. It's not aimed toward any one particular religion. Therefore, the Free Exercise Clause would not pertain. But it is also important to note that some religious practices are okayed, such as Muhammad Ali, who converted to Islam, became a conscientious war objector during the Vietnam War and thus was not drafted because of the Free Exercise Clause, as that would conflict with his religious practices and beliefs. Now, the case that you need to know for the Free Exercise Clause is Wisconsin v. Yoder, 1972. And what this does in a nutshell, and again, I do have a separate video on this on my YouTube channel, but in the Mennonite Amish community, they did not want to send their children to school beyond an 8th grade. As they said, this would interfere with the salvation potentially of their child as well as the parents and put the community in danger. And this, of course, is going to lead to a Supreme Court case, as Wisconsin is going to disagree. But the Supreme Court is going to argue and rule that a high school attendance law, in this case, violated an Amish parent's right to teach their own children under this clause. So requiring children to attend high school after 8th grade was seen as a violation of the Free Exercise Clause, as this was a major tenet of the Amish faith as it forced their children into unwarranted environments. And here's a really neat picture as you see the Amish going toward the Supreme Court building in Washington, D.C. But again, there you go with the Free Exercise Clause. Last slide here that I just want to talk to you about involving the Free Exercise Clause and its limitations. Again, another case that is not required, but Reynolds v. U.S. And in some religions, bigamy and polygamy is practiced. However, bigamy and polygamy are outlawed in most, if not all, states in the United States. And of course, this is a Supreme Court ruling that is still upheld, in which it does say that your religious duty is not a defense for a crime. And again, polygamy and bigamy are an offense under the law. And as if you're familiar with some of the TLC shows, My Five Wives on here on the left and the Sister Wives on the right, technically they are in violation of the law as per this particular Supreme Court case. So it's important to note that there are certainly limitations in the Free Exercise Clause, and there are, of course, exceptions to the Establishment Clause. Again, be very, very familiar with Engel v. Vitale with respect to the Establishment Clause, as well as Wisconsin v. Yoder with respect to the Free Exercise Clause.